The dreaded Lis Pendens. Let's talk about what that Latin term means. Not everybody knows, it is rarely used, and it is seldom a part of a divorce case. It is traditionally resolved for real estate litigation. However, some divorce cases involve claims to the title of a marital home, the mortgage note on the marital home, and so on and so forth. Let's take a recent case from 2024. This case law opinion was filed less than a month ago, which makes this not only fascinating, highly relevant, but also completely up to date. It is contemporary with this conversation with you. In this case, which is, for those of you who may be in a legal profession or just want to look it up, Trujillo versus Garcia, 2024. It is the Third District Court of Appeals opinion from December 18th, 2024. This is a dispute between neighbors because there was property damage and one of the neighbors was engaging in some kind of construction. The trial court granted the motion discharging the Lis Pendens, in other words, eliminating it or canceling it, dissolving it, because there was an insufficient nexus or connection between the property and the Lis Pendens. And this is an appealed case, according to an older opinion from 1985. And this is the foundation. Courts build these things based upon foundational, which is of the utmost importance for you to know. The quote, the purpose of a notice of Lis Pendens is to alert creditors, prospective purchasers, and others to the fact that the title to a particular piece of property is involved in litigation. And now, according to a 2007 opinion, it puts future purchasers on notice there could be a problem with the title to the property. When you purchase a property and you're going through this whole process, a clear title is usually necessary in order to engage in the sale of the property. So anybody that wants to purchase the property might have second thoughts or might back out of the deal if there is unclear title or cloudy title, as we call it in the field of law. The proponent of a Lis Pendens, the person that's asking the court for a Lis Pendens to be granted or accepted, must establish a, quote, fair nexus between the apparent legal or equitable ownership of the property and the dispute embodied in the lawsuit. And that requires the plaintiff's claim could potentially grant an interest in the realty itself before a Lis Pendens can be maintained. When or if a complaint does not establish that connection, the court should discharge the Lis Pendens and dissolve any injunctions against the sale of the property. Fundamentally, a Lis Pendens is improper when the lawsuit itself does not affect the title of the subject property. Well, let's think about a divorce case. In a divorce case, if you and your husband or you and your wife, however the situation may be, whatever the parties may be, if your spouse and you own a marital property together, then we can imagine a circumstance where if you're going to dissolve your marriage, hence marital dissolution, a Lis Pendens might be appropriate. Now, do I think it's hyperbolic? Sometimes. Is it necessary? If somebody has tried to sell the property unfairly, although it likely would not go through, but if they've tried to sell the property behind your back, then maybe a Lis Pendens notice may be appropriate. However, if this is just an ordinary lawsuit, almost every dissolution of marriage involves some kind of property, personal or real property. Not every case has a Lis Pendens. In my experience, maybe 1 out of 100 cases has a Lis Pendens associated or attached with it. It is really uncommon. And we can imagine that it could be quite expensive to file a notice and quite expensive to file a motion to dissolve the Lis Pendens. In order to dissolve that Lis Pendens, the court needs to know that only one person has an ownership interest and not both parties in a marriage. For example, if I own a property and then I get married to my wife, and I then title the house in her name and my name as tenants by the entirety as married folks, then if she were to file a Lis Pendens, if we were to get a divorce, it might be appropriate. I can't say for sure because every circumstance is different. Every case has unique facts, and people challenge these things with or without good cause. People file notices with or without good cause. That's just the fact of litigation. Nonetheless, if there is a nexus, because my wife is now half owner of the house, then it may make sense to have a notice of Lis Pendens. Conversely, if I have a premarital property, I marry my wife, I do not title it in her name, then there is an unclear result. Because if she were to file a lis pendens, well, maybe the sale of the property, or maybe the equitable marital share that she might be entitled to for what we call a coverture fractional amount, I know that sounds like gobbledygook, by the way, and I apologize for those of you following along who are not in law, but your attorney can explain it to you, or if we are your attorney, we will explain it to you clearly and concisely so that you understand all of it, hopefully. But if that's the case, then on the one hand, she might be entitled to some of the money from the house through equitable distribution, but she might not be entitled to half ownership of the house. So then the court has to make a determination. Well, there are other assets to potentially pay my wife in a divorce. There are other assets where I could take a capital asset or money from a bank account and equalize things that way to the extent that they need to be equalized. Certainly that could happen. So maybe the lis pendens is inappropriate and it doesn't impact her title to the property because there is no title for her to the property. So it may be likely that that lis pendens notice will be dissolved by the court. However, if the judge determines that there are no other assets with which to pay my wife, then maybe the lis pendens should stand to alert all these other folks because that property has just become all the more important to the lawsuit. Okay, so let's find out how this case actually ended. That is exactly what happened here. When selling real property in Florida, lis pendenses are seen in foreclosure cases, contract disputes, as I mentioned before, hence civil litigation, or divorce cases, in which an interest in real property is at issue for providing third parties protections over their potential rights to real property. The complaint here in this case does not allege that Trujillo has any special ownership in or lien on Garcia's property. The litigation would not affect the title in any manner, not a manner, but in any manner. There is simply no nexus between the two. This is a lawsuit for damages. The notice of lis pendens is improper and therefore it remains dissolved. The appeal is denied. This is a fascinating case, and I think this is a case on point in many cases involving a lis pendens. And it may be important for you folks to do your research and understand what are the benefits and burdens of filing a motion to dissolve. If it is many opportunities in the case for that property to be at issue, then it may be a good idea. But if you file a motion to dissolve and it turns out, in the context of your case, if it turns out that that property is being contested, well then, that motion for lis pendens or dissolving of lis pendens may be entirely appropriate. Whether or not the court grants it is entirely up to the judge and judicial discretion, even if you have really good case law on point. That is where appeals come from, ladies and gentlemen. I hope you've enjoyed this episode of the Divorce and Family Law Podcast. My name is Attorney Jonathan Jacobs. If you didn't already know, you can call us at any time, 407-335-8113. We would be happy to speak with you about your marital issues, and we look forward to the next podcast episode. Thanks so much.